Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Imagine you just closed on your dream house. The paint is fresh, the keys feel heavy and real in your hand, and for the first time, you have a piece of America to call your own. Then, a week later, a certified letter arrives. It's from a lawyer, and it says that the back third of your brand new backyard, the part with the big oak tree where you plan to build a swing set, doesn't actually belong to you. It belongs to your neighbor, thanks to a 70-year-old surveying error no one ever caught. Or worse, the letter says the person who sold you the house wasn't the only owner. A long-lost heir has emerged, and they are now claiming a stake in your living room. Sound like a nightmare? It happens every single day. The American dream of homeownership is built on a foundation of law so complex, so ancient, and so full of hidden traps that most people don't even know they exist until it's too late. We're talking about invisible claims, phantom owners, and centuries-old rules that can turn your biggest investment into your biggest liability, literally overnight. Most people think buying a house is about mortgages, interest rates, and finding a good school district. And that's part of it. But the real game, the one that determines whether you truly own your home, or you're just a guest waiting to be kicked out, is played in the world of real estate law. It's a world of deeds, titles, liens, easements, and zoning ordinances. And for the average person, it's completely overwhelming. That's about to change. This series is your guide through that legal maze. It's your shield. We are going to demystify the entire process from the ground up. We're going to give you the knowledge that separates savvy owners from vulnerable victims. By the end of this journey, you won't just understand the paperwork you're signing. You'll understand the power, the rights, and the risks that come with it. You'll be able to spot red flags a mile away, ask the right questions, and protect your family and your investment from the kind of legal disasters that have financially ruined others. So where do we start? We start with the most fundamental question of all. What are you actually buying when you buy a house? You probably think you're buying land in a building. That's what we all think. But in the eyes of the law, you're not. You are buying something far more abstract and far more important. You are buying a bundle of rights. This is the single most important concept in all of US real estate law, so I want you to picture it. Imagine a bundle of sticks, all bound together. In a perfect world, when you buy a piece of property, you get the entire bundle. Each stick in that bundle represents a specific right you have over that property. Let's break down the 5 most important sticks. First, you have the right of possession. This is the most obvious one. It's the right to actually occupy and hold the property. It's the stick that lets you put a key in the door, move your furniture in, and call that place home. It's your physical claim to the space. Second is the right of control. This is the stick that says you get to use the property in any way you want, as long as it's legal. You want to paint your bedroom black? Go for it. You want to build a giant vegetable garden in the front yard? That's your right of control. You are the master of your domain. Third, we have the right of enjoyment. This is a bit different from control. This is your right to use and enjoy the property in peace, without interference from others. If your neighbor decides to start a death metal band and practice in their garage at 3 a.m. every night, they are interfering with your right of enjoyment. This is the stick that protects your peace and quiet. Fourth is the powerful right of disposition. Disposition is just a fancy word for getting rid of something. This stick gives you the right to sell the property, to lease it to a tenant, to give it away in your will, or even to burn it to the ground if you wanted to, though other laws might have something to say about that. It's the right to transfer your ownership to someone else. And finally, the 5th stick is the right of exclusion. This is a big one. This is your right to tell other people to get off your property. It's the legal power behind your no trespassing sign. It allows you to control who comes and who goes. It's the right to say, "This is mine, and you can't be here without my permission." So you have possession, control, enjoyment, disposition, and exclusion. When you have all 5 of these sticks, all of these rights, you have what's called fee simple absolute ownership. That's the legal term for the highest possible form of ownership. It's the whole enchilada. It's what everyone thinks they're getting when they buy a house. But here's the billion-dollar secret of real estate. You almost never get the whole bundle. In virtually every single property transaction in the United States, some of your sticks have already been given away or taken by someone else. Your job as a buyer is to figure out exactly how many sticks you're actually getting. So who else has sticks from your bundle? Well, the first and most powerful entity is the government. The government always keeps a few of your sticks for itself, whether you like it or not. The first stick the government keeps is the right to tax. Your local, state, and federal government have the right to levy taxes on your property. And if you don't pay them, they can use their stick to force the sale of your home to get their money. You don't own your property free and clear of the government's right to tax it. The second government stick is called eminent domain. This is the big one. Eminent domain is the right of the government to take your private property for public use, even if you don't want to sell. Now, the Constitution says they have to pay you just compensation, but they absolutely have the right to force you out to build a highway, a school, or a park. They have a stick from your bundle that allows them to take the entire thing. The third government stick is police power. This isn't about police officers. It's about regulation. This is the government's right to create laws to protect the health, safety, and welfare of the public. Zoning laws are the most common example. Your right of control might let you paint your house pink, but the government's police power stick, in the form of a zoning ordinance, can stop you from building a factory in your residential neighborhood. They are limiting your right of control for the good of the community. But the government isn't the only one holding your sticks. Private individuals and corporations can have rights to your property too. When you get a mortgage, you are voluntarily giving the bank a stick from your bundle. This is called a lien. A lien is a legal claim against a property to secure a debt. The mortgage gives the bank the right to seize and sell your property, your right of disposition, if you fail to make your payments. You don't truly have the full right to sell your home until that bank's lien is paid off. The bank is holding one of your most important sticks. Then you have things called easements. An easement is the right for someone else to use a part of your property for a specific purpose. The most common example is a utility easement. The electric company might have an easement, a stick from your bundle, that gives them the right to come onto your land to access and repair power lines. You can't tell them no, they have a legal right. Your neighbor might have an easement to use your driveway to get to their garage. They don't own your driveway, but they own the right to use it, and that right diminishes your right of exclusion. So you see, that nice neat bundle of sticks is rarely whole. It's more like a puzzle. When you buy a property, you aren't just buying the land and the house. You are buying a specific collection of rights that remains after the government, the bank, the utility company, and maybe even your neighbor have taken theirs. The process of figuring out exactly who owns which rights, which sticks, is the absolute core of a safe real estate transaction. It's how you discover that 70-year-old surveying error, or that long-lost heir, before you buy the house. This process is called examining the chain of title. And the final report card, the document that tells you exactly which sticks you're getting, is your title insurance policy. Understanding title is the single most critical skill for any prospective homeowner. It's the difference between a secure investment and a catastrophic mistake. And in the next part, we are going to dive deep into it. We'll uncover how to trace the history of a property, what it means to have a clear versus a cloudy title, and reveal the one document that can protect you from claims against your home, even from people you've never met. So let's start by putting on our detective hats. Because before you can own a piece of property, you need to investigate its past. This isn't just a casual glance. It's a full-blown historical deep dive called a title search. The goal is to unearth and examine every single public record connected to that specific plot of land, sometimes going back 100 years or more. We're talking about building the property's official biography. This biography is called the chain of title. Think of it like a family tree for your house. Each link in the chain is a former owner. The title search traces the ownership from the current seller back to the previous owner, and the owner before that, and so on, creating an unbroken chain of transfers. Each transfer should be documented by a legal instrument, most commonly a deed. The deed is the official paper that says, I, the seller, am giving my ownership rights to you, the buyer. If any link in that chain is weak, broken, or missing, you've got a serious problem. In a perfect world, the detective work of the title search reveals a beautiful, clean, unbroken chain. Every sale was legitimate. Every mortgage was properly recorded and paid off. There are no surprise claims, no lingering debts, no long-lost relatives with a stake in the land. This is what we call a clear title, or a marketable title. It means the seller has the undisputed right to sell the property, And once you buy it, you will have the undisputed right to own it. It's the green light, the clean bill of health, the ultimate peace of mind. But we don't live in a perfect world. More often than you'd think, the title search uncovers issues, ghosts from the property's past. This is what's known as a cloudy title or a title defect. A cloud is any issue that casts doubt on the seller's absolute ownership. It creates uncertainty, and in real estate, uncertainty is a deal killer. So what kind of ghosts are we talking about? Let me paint you a picture. Imagine you're buying a charming bungalow. The title search goes back 40 years and finds that a contractor who put a new roof on the house was never paid his final $5,000. He filed a mechanic's lien against the property. A lien is a legal claim against an asset to satisfy a debt. That lien was never officially released. It's still sitting there in the county records, a tiny legal time bomb. As the new owner, that contractor's ghost could come back to haunt you for that money. That's a cloud. Or how about this one? The seller, let's call him Bob, inherited the house from his Aunt Clara. What Bob didn't know is that Aunt Clara had a secret son from a youthful romance who she never mentioned in her will. That son, now a grown man, could potentially surface years after you've bought the house and make a claim as a rightful heir to the property. That is a massive storm-sized cloud. It can even be something as simple and infuriating as a clerical error. 50 years ago, a clerk at the county recorder's office misspelled a name on a deed or wrote down the wrong lot number. That tiny typo creates a break in the chain of title. It creates a legal ambiguity that has to be fixed, a process that can involve tracking down people who may have moved or passed away decades ago. And it gets more complicated. A title search might uncover an easement you knew nothing about. An easement is the right for someone else to use a portion of your property for a specific purpose. You think you're buying a private backyard, but it turns out your neighbor has a 50-year-old legal right to drive across it to get to their garage. Or maybe the local utility company has a recorded easement to dig up your prize-winning rose garden anytime they need to access underground cables. There could be boundary disputes, where a survey shows the seller's fence is actually 3 feet onto the neighbor's land. There could be forgeries on old documents, or deeds signed by someone who was mentally incompetent or a minor at the time. All of these things cloud the title and jeopardize your ownership. So you're probably thinking, this is terrifying. How can anyone ever buy a house with confidence? If a simple typo from 1962 can threaten my ownership of a home I paid hundreds of thousands of dollars for, what can I possibly do to protect myself? This brings us to the single most important document I mentioned before. It's your shield. It's your fortress against all these ghosts of the past. It's called title insurance. Unlike other insurance policies that protect you from future events, like a car accident or a house fire, title insurance does the opposite. It protects you from things that have already happened in the past. It's a one-time purchase you make at closing that protects you for as long as you or your heirs own the property. Here's how it works. A title insurance company performs that exhaustive title search we talked about. They are the detectives. Their job is to find any and all of those clouds. If they find minor issues, they'll work to cure them before you close on the house, getting that old lien released, for example. But what if they miss something? What if that long-lost heir of Aunt Clara really does show up on your doorstep 5 years from now with a lawyer and a legitimate claim to your house? If you have an owner's policy of title insurance, you don't panic. You simply call your title insurance company. They will handle it. They are legally and financially obligated to defend your title in court. They will pay for the attorneys, the court fees, all of it. And if, in some worst-case scenario, the claim proves to be valid and you lose the house, the title insurance company will compensate you for your financial loss, up to the full purchase price of the home. It protects your single biggest investment from being wiped out by a mistake made before you were even born. Now, it's critical to understand there are 2 types of title insurance. There's the lender's policy, and there's the owner's policy. When you get a mortgage, your lender will absolutely require you to buy a lender's policy. This policy protects their investment, not yours. It ensures that if a title issue pops up, the bank will get its money back. The owner's policy, on the other hand, is what protects you, the homeowner. It protects your down payment, your equity, your right to live in and enjoy your property. In some parts of the country, the seller pays for this policy. In others, the buyer does. Sometimes it's even considered optional. But let me be crystal clear. It is never ever truly optional. The risk of not having it is catastrophic. For a one-time fee, you are buying complete financial security against the entire history of your property. It is the only way to turn a potentially cloudy title into a permanently clear sky. So, we've secured our ownership and defended against the past. We have our shield. Now, we need to talk about the rulebook for the transaction itself. The most important document you will sign in the entire process besides the deed and the mortgage. It's the blueprint for the whole deal. A document filled with dates, deadlines, and clauses that can either protect you or leave you dangerously exposed. It's called the Purchase and Sale Agreement, and in our next part we are going to dissect it line by line. We'll expose the common traps, the weasel clauses that let sellers escape, and the critical contingencies you must have in place to ensure you can walk away from a bad deal with your deposit and your sanity intact. So let's pull out the magnifying glass and look at this document. Most people see a purchase agreement as a formality, a dense stack of paper their agent tells them to sign. That is a colossal mistake. Think of this contract not as a piece of paper, but as the rulebook for the single biggest financial game of your life. Every sentence, every checkbox is a rule that can either protect you or trap you. And the most important rules, the ones that give you power, are called contingencies. Contingencies are your escape hatches. They are legally binding what-if scenarios written directly into the contract. They are your get-out-of-jail-free cards that let you walk away from the deal with your deposit money safely back in your pocket if certain conditions aren't met. Without them, the moment you sign that offer, you are legally obligated to buy that house, no matter what horrible secrets you uncover later. So let's talk about the big three, the absolute, non-negotiable contingencies you must understand. First, and in my opinion the most critical, is the inspection contingency. This is your X-ray vision clause. It gives you the legal right to hire a professional inspector, or multiple specialists like a roofer, an electrician, or a structural engineer, to come into the house and tear it apart, metaphorically speaking. They will crawl into the attic, squeeze into the crawl space, test every outlet, and run every faucet. They are looking for problems the seller either didn't know about or, more cynically, didn't want you to know about. This contingency gives you a specific window of time, usually something like 7 to 14 days, to get these inspections done. And here's the beautiful part. Based on that inspection report, you have 3 options. Option 1. If the report is clean, you move forward. Great. Option 2. If the inspector finds problems, say, the furnace is on its last legs and there's evidence of an old leak under the bathroom sink, you can go back to the seller and renegotiate. You can say, I'll still buy your house, but you need to either fix these things before we close, or you need to give me a credit of $10,000 so I can fix them myself. This is a huge point of leverage. But it's option 3 that is your ultimate safety net. If the inspector finds something catastrophic, a cracked foundation, widespread mold, a completely shot electrical system, and you and the seller can't agree on a solution, you can invoke the inspection contingency and walk away. You simply state that the inspection results are unsatisfactory, and the contract is void. You get your deposit back, and you walk away from a money pit that could have financially ruined you. Ignoring this or shortening the window too much is like playing Russian roulette with your life savings. Next up is the appraisal contingency. This one is all about protecting you from your own emotions in a hot market. When you're in a bidding war, it's easy to get caught up and offer a price that might be more than the house is actually worth. You think, I have to have it. But your mortgage lender doesn't care about your feelings. They are a cold, calculating business, and they will not lend you more money than the house is worth. So they hire a professional, third-party appraiser to determine the home's fair market value. The appraisal contingency says that the house must appraise for at least the price you agreed to pay. Let's play this out. You offer $500,000 for a house, and the seller accepts. But the appraiser comes back and says, based on comparable sales and the home's condition, this property is only worth $475,000. Now you have what's called an appraisal gap of $25,000. Without an appraisal contingency, you are legally on the hook. The bank will only give you a loan based on the $475,000 value, so you would have to magically come up with an extra $25,000 in cash at closing, on top of your down payment. For most people, that's impossible. But with the appraisal contingency, you're protected. You can go back to the seller and say, look, it didn't appraise. You need to lower the price to the appraised value. If they refuse, you can walk away from the deal, deposit in hand. This clause is the essential reality check that ensures you don't overpay. The third pillar of your protection is the financing contingency, also known as the mortgage contingency. This one is simple but powerful. The contract is only binding if you can actually get the loan. Life happens. Maybe your credit score takes an unexpected hit a week after your offer is accepted. Maybe you or your partner lose a job. Maybe the bank's lending standards suddenly tighten. Any of these things could cause your pre-approval to turn into a final denial. Without a financing contingency, this would be a disaster. The seller wouldn't care that your loan fell through. They would see it as you failing to hold up your end of the bargain. They could keep your entire earnest money deposit, and in some states they could even sue you for damages. The financing contingency prevents this nightmare. It states that if, after a good faith effort, you are unable to secure a mortgage on the terms specified in the contract, the loan amount, the interest rate, within a certain period, you can cancel the contract and get your deposit back. It is the ultimate financial parachute. Now, in a hyper-competitive market, you will hear people talking about waiving contingencies to make their offer look more attractive to a seller. Let me be crystal clear. For a beginner, this is monumentally dangerous. Waiving the inspection contingency means you are buying the house, as is in the truest sense of the word. If you discover a $10,000 termite infestation or a $50,000 foundation issue the day after you close, that is 100% your problem. Waiving the appraisal contingency means you are guaranteeing you will pay the difference in cash if it appraises low. Waiving the financing contingency means you're gambling that nothing in your financial life will change. And if it does, you're prepared to lose your deposit and potentially face a lawsuit. It's like jumping out of a plane and deciding to pack your parachute on the way down. It might work, but the risk is catastrophic. Now I know what you're thinking. What about that as-is clause that sellers love to put in the listing? This is one of the most misunderstood concepts, and it's a perfect example of a weasel clause. If you don't understand it, many buyers think as-is means they can't inspect the property or ask for repairs. That is not true. As-is simply means the seller is not willing to make any repairs up front. It does not, and I repeat, does not take away your right to have an inspection contingency. You can still inspect an as-is property from top to bottom. And if your inspection reveals a swamp monster living in the basement, your inspection contingency still gives you the absolute right to walk away and get your deposit back. The as-is clause only means the seller has preemptively said no to any repair requests. Your power doesn't come from asking them to fix things. Your power comes from your ability to walk away from the deal if you don't like what you find. Never let a seller or an agent convince you that as-is means you give up your right to know exactly what you're buying. These contingencies, inspection, appraisal, and financing are your shield. They are what transform a purchase agreement from a binding trap into a flexible framework. They give you time, information, and the power to make a smart decision instead of an emotional one. But all of this protection hinges on one very important piece of the puzzle. That chunk of money you have to hand over right at the beginning. Your skin in the game. It's called the earnest money deposit. How much should it be? Who holds on to it? And what are the exact rules that determine whether you get it back or the seller gets to keep it? That check you write is the financial hostage in this entire negotiation. And in the next part, we are going to lay out the precise strategy to make sure you don't lose it. That earnest money deposit is a promise, a sign of good faith, but it's also leverage. It's a cash guarantee that you're serious. And the moment that check leaves your hand, it enters a legal gray zone governed by one of the most critical parts of your purchase agreement: contingencies. Think of contingencies as the ultimate get-out-of-jail-free cards in the monopoly game of real estate. They are clauses written into your contract that say, I, the buyer, will purchase this home if certain conditions are met. If those conditions are not met, these clauses give you the legal right to walk away from the deal and, most importantly, take your earnest money with you. Without them, that deposit is as good as gone if you get cold feet or discover a nasty surprise. So what are these magic clauses? There are three main contingencies that form the buyer's holy trinity of protection. First, and perhaps the most famous, is the inspection contingency. This clause gives you the right to hire a professional inspector to go through the house with a fine-tooth comb. This isn't your father-in-law who's good with tools. This is a licensed professional trained to spot the hidden disasters that can turn a dream home into a financial nightmare. They'll climb on the roof, crawl under the house, test the electrical, check the plumbing, and look for signs of structural damage, termites, mold, and 1,000 other potential problems. Let's play this out. You find a beautiful house. It looks perfect. The paint is fresh, the kitchen is updated. You make an offer, it's accepted. You're ecstatic. Then your inspector, armed with a flashlight and a moisture meter, goes into the basement. Behind a newly painted wall, he finds a massive crack in the foundation, cleverly hidden. The report comes back with a $40,000 repair estimate. Without an inspection contingency, you are in a world of hurt. You're contractually obligated to buy a house with a broken foundation. Backing out now would mean forfeiting your earnest money, and you could even be sued by the seller for breach of contract. But with the contingency, the power dynamic shifts completely. You now have options. You can go back to the seller and say, "Look at this report. You can either fix this foundation before we close, give me a $40,000 credit so I can fix it myself, or we can renegotiate the price." And if the seller refuses, you can activate the contingency, terminate the contract, and your earnest money is returned to you safe and sound. The inspection contingency is your eject button for a bad deal. But you have to be careful. This power isn't unlimited. It exists within a specific time frame, usually 7 to 17 days from when your offer is accepted. If you don't get your inspections done and raise your objections within that window, the contingency expires. Your eject button vanishes. The deal automatically moves forward, and you've lost your chance to back out based on the home's condition. The second pillar of your defense is the appraisal contingency. This one is all about the money. When you get a mortgage, the bank is not just lending money to you, they are investing in the property. They will not lend you more money than the house is actually worth. To determine its value, they send out a licensed appraiser to give a professional, unbiased opinion of the property's market value. Imagine you're in a hot market. Bidding wars are everywhere. You offer $600,000 for a house listed at $550,000, and you win. You're celebrating, until the bank's appraiser comes back with their report. They've looked at the house, analyzed the recent sales of similar homes in the area, and they conclude the house is only worth $570,000. This creates what's called an appraisal gap of $30,000. The bank will only give you a loan based on the $570,000 value. You are now $30,000 short. This is where the appraisal contingency saves you. With it, you can go back to the seller and say, "The house didn't appraise. We need to lower the price to $570,000. They agree, fantastic. If they refuse, you can walk away from the contract and again you get your earnest money back. The third option is that you can choose to make up the difference in cash, but the contingency gives you that choice. Without it, you have no choice. You are legally on the hook to come up with that extra $30,000 in cash. If you can't, you're in breach of contract. You lose your earnest money and the seller can once again sue you for damages. In fiercely competitive markets, buyers are often tempted to waive the appraisal contingency to make their offer more attractive to the seller. This is a massive financial gamble. It's like telling the seller, "I will buy your house for this price, no matter what the bank thinks it's worth, and I have the cash to cover any shortfall." It's a powerful move, but one that can backfire spectacularly. Finally, we arrive at the most critical contingency of all, the financing contingency, sometimes called a mortgage contingency. This clause is beautifully simple. It says, "I will buy this house if and only if I can secure a loan to do so." Many buyers think their pre-approval letter from a bank is a golden ticket. It's not. A pre-approval is just a preliminary check. It's the bank saying, "Based on what you've told us so far, you look like a good candidate for a loan." The real test is underwriting. This is when the bank puts your entire financial life under a microscope, verifying your income, your employment, your debts, your credit history, everything. And things can go wrong. People lose their jobs during escrow. A forgotten medical bill can pop up on a credit report, tanking a credit score. The bank's underwriters might decide your debt-to-income ratio is too high. Suddenly, that pre-approval evaporates, and the final loan is denied. If you have a financing contingency, this is a disappointing but financially safe event. You show the seller the loan denial letter, you terminate the contract, and you get your earnest money back. It protects you from life's unexpected curveballs. But if you waive that contingency, you have just entered the real estate twilight zone. You are now legally obligated to buy a multi-$100,000 asset with money you do not have and cannot get. The seller doesn't care that your loan fell through. They have a valid contract. They will keep your earnest money, which could be tens of thousands of dollars, and they have every right to sue you for specific performance, trying to force the sale, or for damages related to putting their house back on the market. Waiving the financing contingency is the single riskiest thing a typical buyer can do. These three contingencies, inspection, appraisal, and financing, are your shield. They are the legal mechanisms that turn a purchase agreement from a rigid trap into a flexible process. They ensure that your earnest money, your financial hostage, only gets handed over if the house is what it seems, it's worth the price, and you can actually pay for it. But here's the catch. These protections are not automatic. They must be explicitly written into your purchase offer, with clear deadlines. The standard contract is a blank slate. You and your real estate agent are the ones who build the fortress. You decide how long the inspection period is. You decide if you need an appraisal contingency. You decide if you need the safety net of a financing contingency. Every decision you make about these clauses shifts the balance of risk between you and the seller. A seller naturally wants an offer with zero contingencies. It's the closest thing to a guaranteed sale. And as a buyer, you want an ironclad contract with every protection imaginable. The final agreement is a negotiation between these two poles. Now, you've built your fortress of contingencies. You're protected from the house's physical flaws, from a low appraisal, and from a financing collapse. But what about the things you can't see? What if the seller is actively hiding something? A leaky roof they just painted over? A history of flooding in the basement they conveniently forgot to mention? What about something more sinister? What if a violent crime happened in the master bedroom? Is the seller legally required to tell you? That is the world of seller disclosures, and it's one of the most fascinating and sometimes terrifying areas of real estate law. We're about to dive into what sellers have to tell you, and what they can legally hide in the very next part. So you're standing in what you think is your dream home. The light is perfect, the layout flows, you can already picture where your couch will go. The seller, a friendly-looking person, tells you the house has been nothing but wonderful. But what if, just beneath that fresh coat of paint in the basement, there's a dark, sprawling water stain from a flood they had last spring? What if the quirky flicker in the dining room light isn't a loose bulb, but a symptom of ancient, faulty wiring that's a genuine fire hazard? What the seller knows and what they're legally required to tell you can be the difference between a dream home and a financial nightmare. This is the entire legal concept of seller disclosures. It's a battle against an age-old legal doctrine called caveat emptor, which is Latin for, let the buyer beware. For centuries, the law essentially said, hey, you're buying the house. It's your job to find everything wrong with it. If you miss something, that's on you. It was a brutal system that heavily favored the seller, who held all the cards and all the secrets. But over the last several decades, state laws have evolved, recognizing that this is fundamentally unfair. The person who has lived in the house for 10 years will always know more than a buyer who has spent 30 minutes walking through it. So modern real estate law created the seller's property disclosure statement. This isn't just a friendly chat. This is a formal, legally binding document. It's a multi-page checklist where the seller is forced to go on the record about the condition of their property. They have to answer specific questions about the roof, the plumbing, the electrical system, the foundation, the HVAC, and more. They'll check boxes for yes, no, or unknown to questions like, are you aware of any past or present water leakage in the basement? Or are you aware of any defects in the electrical system? The core of this entire process revolves around a single, powerful legal term: material defect. A material defect is any problem with the property that could significantly impact its value or a buyer's decision to purchase it. A sticky doorknob is not a material defect. A cracked foundation that could cost $50,000 to repair absolutely is. A slow-draining sink might be an annoyance. A collapsed sewer line is a material defect. The seller has an affirmative duty to disclose any known material defects. The key word there is known. They don't have to go looking for problems. They aren't required to hire an inspector to find issues. But if they know about a problem, they generally have to disclose it. Lying on that form isn't just bad form. It's fraud. Let's break down the big categories. First, you have the obvious structural and mechanical issues. This is the stuff we just talked about. The leaky roof, the faulty furnace, the termite damage they had treated 2 years ago. These are the bread and butter of disclosures. Second, you have environmental hazards. This is a huge one. The most famous is the federal law requiring sellers of homes built before 1978 to provide a lead-based paint disclosure. They have to give you a pamphlet about lead hazards and disclose any known lead paint in the house. But it goes further. States have their own rules about things like radon gas, a naturally occurring radioactive gas that can seep into basements, asbestos used in old insulation, or even whether the property is built on an old landfill or near a hazardous waste site. These are things you can't see or smell, but they can have serious long-term health consequences. But here's where it gets truly fascinating, and where the laws vary wildly from state to state. we enter the world of stigmatized properties. What if someone died in the house? Does the seller have to tell you? Well, it depends. If the death was from natural causes like an elderly person passing away in their sleep, almost no state requires disclosure. But what if it was a murder? Or a suicide? This is a psychological stigma, not a physical one. The house is structurally sound, but the event could still dramatically affect its value and a buyer's willingness to live there. In a state like California, a death on the property within the last 3 years must be disclosed. In a state like Texas, a seller is only required to disclose a death if the buyer specifically asks about it. And in many other states, there's no requirement to disclose it at all, unless it was caused by a physical condition of the property, like a faulty gas line. What about hauntings? Believe it or not, this has gone to court. The most famous case, Stambovsky versus Ackley, involved a house in New York that the seller had actively promoted in the community as being haunted by ghosts. When a new buyer found out, he wanted to back out. The court famously ruled that since the seller had told the public the house was haunted, it was a condition that she couldn't then deny to the buyer. This is a rare exception, though. In general, paranormal activity is not considered a material defect. So what can a seller legally hide? This brings us to the biggest loophole in all of disclosure law: the "I didn't know" defense. The seller's duty is to disclose what they know. If they genuinely are not aware of a problem, they can't be held liable for not disclosing it. If a slow leak has been rotting out the subfloor under the dishwasher for 5 years, but it hasn't yet caused a visible stain on the ceiling below, the seller might truthfully check no on the disclosure form when asked about plumbing leaks. They aren't lying. This is precisely why the disclosure statement is not, and never should be, a substitute for a professional home inspection. The disclosure tells you what the seller knows. The inspection is designed to find what they don't know. And what about those as-is sales? You see that phrase all the time. Many people think this is a magic wand that sellers can wave to avoid disclosing any problems. This is a dangerous myth. In most states, selling a property as-is simply means the seller is not willing to make any repairs. It does not absolve them of their legal duty to disclose known material defects. If they know the basement floods every spring, they still have to tell you, even if they're selling it as-is. Trying to use as-is to hide a known major problem is a classic path to a lawsuit. So what happens if you buy a house, move in, and during your first big rainstorm, a waterfall starts pouring through your living room ceiling? And you later find out from a neighbor that the sellers had the same problem every year? You've discovered a lie on the disclosure form. You have recourse. You can sue the seller for fraud or misrepresentation. Depending on the severity and the laws in your state, you could potentially recover the cost of the repairs, or in some truly egregious cases, you might even have the right to rescind the sale entirely, effectively giving the house back and getting your money back. But this is a long, expensive, and stressful legal battle. That's why you have to treat the seller's disclosure statement as your first piece of intelligence, not your last. It's a starting point for your investigation. When you read that form, you're not just a buyer, you're a detective. If the seller checks unknown for the age of the roof, that's a red flag to investigate further. If they disclose a minor plumbing leak that was repaired, you need to find out exactly who repaired it and how. Every yes on that form is a thread you must pull. The disclosure is a window into the home's history, but it's a window that's only opened as wide as the seller chooses, or is legally forced, to open it. Your job, with the help of professionals, is to throw that window open all the way and shine a light into every dark corner. Because the seller's story is only one part of the equation. To get the full story, you have to bring in your own expert, a trained professional whose only job is to be skeptical, to look past the fresh paint and staging, and to find the secrets the house itself holds. That expert is the home inspector, and they are your single most important ally in this entire process. What they do, how they do it, and what happens when they miss something critical, that's where we're going next. The home inspection is not just a formality. It's an autopsy on a house that's still standing. Think of the inspector as a detective, and the house is the scene of 100 tiny potential crimes against your bank account. They aren't there to tell you if you should buy the house. Their job is to give you a detailed, unbiased report on its condition, so you can make an informed decision. This is a critical distinction. An inspection is not a pass-fail test. It's a fact-finding mission. So what are they actually looking for? They follow a methodical process, a top-to-bottom, inside-and-out examination. They'll get on the roof, checking for damaged shingles, bad flashing around chimneys, and signs that the roof is nearing the end of its life. A new roof can cost $10, $20, even $30,000. That's a fact you want before you sign on the dotted line. They'll examine the exterior, the siding, the trim, the grading of the land around the house. Is the ground sloping towards the foundation instead of away from it? That's a neon sign flashing future water problems. They'll check the foundation itself for cracks. Now, not all cracks are a 4-alarm fire. Some are normal settling. But the inspector knows how to tell the difference between a harmless hairline crack and a structural fissure that signals a catastrophic failure in the making. Inside, they go room by room, but they're not looking at the paint color. They're testing every single electrical outlet. They're looking for ungrounded plugs, faulty wiring, or an overloaded electrical panel that looks like a rat's nest of fire hazards. They're running the water in every sink and shower, checking for pressure, drainage, and evidence of leaks under the cabinets. They're hunting for the subtle signs of water intrusion, a faint stain on the ceiling, a slightly warped piece of baseboard, the faint, musty scent of a hidden mold colony. And then they go for the big three: the HVAC system, the water heater, and the plumbing. These are the expensive, vital organs of the home. They'll check the age and condition of the furnace and the air conditioner. They'll look for rust on the water heater, a sign it could fail at any moment. They'll venture into the dark, creepy places you wouldn't, the crawl space, the attic, looking for leaky pipes, damaged insulation, improper ventilation, or even evidence of pests. After 3 to 4 hours of this intensive investigation, you get the Holy Grail, the inspection report. This isn't a simple checklist. A modern report is a 40, 50, even 80-page document filled with high-resolution photos, detailed descriptions of every issue they found, and recommendations. It will categorize problems into different levels of severity: major defects, safety hazards, items needing repair or replacement, and things to monitor. A major defect might be a failing foundation or a roof that needs immediate replacement. A safety hazard could be exposed electrical wiring or a lack of carbon monoxide detectors. Repair items might be a leaking faucet or a broken window seal. This report is your roadmap and your leverage. This is where the inspection contingency in your contract becomes your superpower. Remember that clause? It gives you a specific window of time, usually 7 to 14 days, to conduct your inspection and decide how to proceed. Once you have the report, you and your agent will review it, and you essentially have 4 options. Option 1, you accept the house as is. If the report only turns up minor, manageable issues, you might decide it's not worth haggling over and move forward. Option 2, you ask the seller to make repairs. You can create a list of the specific items from the report, usually focusing on the major defects or safety hazards, and request that the seller hire licensed professionals to fix them before closing. Option 3, you ask for a credit. Maybe you don't trust the seller's choice of contractor, or maybe you'd rather oversee the work yourself after you own the home. In this case, you can negotiate for the seller to give you a credit at closing, which is basically a discount on the price to cover the cost of future repairs. Option 4, you walk away. If the inspection uncovers a Pandora's box of problems, a cracked foundation, widespread mold, a completely shot electrical system, and you can't reach an agreement with the seller on repairs or credits, your inspection contingency allows you to terminate the contract and, in most cases, get your earnest money deposit back. It is your ultimate escape hatch. But what happens if the worst-case scenario unfolds? What if you buy the house, move in, and a month later, the ceiling collapses from a leak the inspector completely missed? Do you have any legal recourse? The answer is, it's complicated and often disappointing. The first thing you need to do is pull out the pre-inspection agreement you signed. Buried in that fine print, you will almost certainly find a limitation of liability clause. This is one of the most misunderstood and important clauses in the entire process. In most cases, it states that if the inspector misses something, their liability is limited to the fee you paid for the inspection. That's it. You paid them $500, they missed a $50,000 foundation problem, and your legal recourse against them might be capped at getting your $500 back. It sounds insane, but courts have generally upheld these clauses. The rationale is that an inspection is a limited, visual, non-invasive service performed for a relatively small fee. It's not a warranty or an insurance policy against future problems. The inspector can't see through walls, predict the future, or disassemble the house to check every component. So, are you just out of luck? Not necessarily, but the bar for a successful lawsuit is incredibly high. To win a case against a home inspector, you typically have to prove gross negligence or fraud. You have to demonstrate that they failed to report a significant defect that was readily visible and accessible at the time of the inspection, and that this failure fell far below the professional standard of care. For example, if there was a massive dark water stain on the living room ceiling and their report says nothing about it, you have a strong case. They were negligent. But if a pipe inside a wall that showed no outward signs of a problem burst 6 months after you move in, that's not something they could have possibly seen. It's just the unfortunate reality of homeownership. Most inspectors carry what's called errors and omissions insurance, or E&O. But this insurance is there to protect them from lawsuits related to negligence. It doesn't just automatically pay out if a problem arises. You still have to prove your case. This is why choosing your inspector is so profoundly important. Don't just go with the cheapest option. Don't just blindly accept the person your agent recommends without doing your own research. Look for inspectors certified by major organizations like ASHI or Internachi. Ask to see a sample report so you can judge the quality and detail of their work. Read online reviews. A great inspector is worth their weight in gold because they're not just checking boxes. They're protecting you from a potential financial catastrophe. So you've survived the inspection, you've negotiated the repairs, and you're ready to move forward. The house has been poked, prodded, and scanned. But there's another expert who has to give their blessing. Someone who works for the bank, not for you. Their job isn't to find leaks or faulty wiring. Their job is to decide if the house is actually worth the price you agreed to pay. This is the appraiser, and their one-page report can make or break your entire deal in a heartbeat. What happens when the appraisal comes in low? That's where the real panic sets in, and that's exactly what we're diving into next. The phone rings. It's your agent. You're expecting good news, a simple confirmation that everything is on track. Instead, you hear a phrase that makes your stomach drop. The appraisal came in low. Suddenly, the smooth path to your new home has a giant, gaping chasm in the middle of it. Your offer was $500,000. The appraiser, this impartial expert sent by the bank, says the house is only worth $480,000, a $20,000 gap. And just like that, the bank tells you they'll only lend you money based on their appraiser's number, not yours. The dream is teetering on the edge of a cliff. Is it over? Do you lose the house? Do you lose your earnest money? This moment, the appraisal gap, is one of the most terrifying and misunderstood hurdles in the entire home buying process. But it is not a deal killer. It is a negotiation point. It is a legal and financial puzzle that you now have to solve. And the key to solving it lies within the contract you already signed. First, let's understand why the bank is doing this. To them, the house isn't a home. It's collateral. It's the security for the massive loan they're giving you. If you stop paying your mortgage, they need to be able to sell the house and get their money back. If they lend you money based on a $500,000 price, but the house is only worth $480,000, they're already starting out $20,000 in the hole. From their perspective, it's an unacceptable risk. The appraisal is their legal and financial shield. So the bank won't budge. The problem is now squarely between you and the seller. You have 3 primary paths forward, and a 4th more secret path we'll get to in a moment. Each one is a strategic decision. Path number 1. Renegotiate with the seller. This is the most common first step. Your agent goes back to the seller's agent, armed with a powerful new piece of evidence, the official appraisal report. The conversation is no longer about feelings or what you're willing to pay. It's about a third-party professional valuation. You can now say, look, we love the house, but the bank's independent expert agrees with neither of our numbers. They say it's worth $20,000 less. We're asking you to reduce the sales price to the appraised value of $480,000. Now the seller has a choice. If they're motivated to sell, if they've already bought another house, or if they just want the deal done, they might agree immediately. Problem solved. But what if they say no? They might believe their house is worth the full $500,000. They might have other offers waiting. They could say, tough luck. Find the money or walk away. More often, you'll land somewhere in the middle. Maybe you offer to split the difference. They come down $10,000 in price and you come up with an extra $10,000 in cash. This is a classic negotiation, and it all depends on the motivations of both sides. Path number 2. You pay the difference. This is the appraisal gap. If the seller won't lower the price, and you want the house badly enough, you can choose to cover that $20,000 shortfall with your own cash. This is on top of your down payment and closing costs. It's a significant financial hit. Why would anyone do this? In a hyper-competitive market, this is sometimes the only way to win. Buyers will even write something called an appraisal gap contingency into their initial offer, stating upfront that they are willing to pay a certain amount over the appraised value in cash. This tells the seller that a low appraisal won't derail the deal and makes your offer incredibly strong. But you have to understand the legal and financial reality of what you're doing. You are knowingly and willingly paying more for a house than the bank believes it is worth. You're starting with negative equity from the bank's point of view. You're betting on the future, hoping the market continues to rise and the value catches up. It's a high-stakes gamble, and you have to be 100% certain the house is worth that extra cash to you personally. Path number 3: walk away. This is your legal escape hatch. Remember that appraisal contingency we talked about in the last part? This is precisely why it is one of the most critical clauses in your purchase contract. An appraisal contingency legally states that if the property does not appraise for at least the purchase price, you, the buyer, have the right to terminate the contract and, most importantly, get your earnest money deposit back in full. Without this clause, if you walked away because of a low appraisal, the seller could potentially keep your deposit as damages for you breaking the contract. With the contingency, you have a protected, legal exit. It's the ultimate safety net. It allows you to say, the numbers don't work, the risk is too high. We are respectfully terminating the agreement as per our contractual rights. It's a painful decision, especially if you love the house, but it can save you from a catastrophic financial mistake. So, you can renegotiate, you can pay the gap, or you can walk away. But there is a fourth, less traveled path. You can challenge the appraisal itself. Appraisers are human. They make mistakes. An appraisal is an opinion of value, albeit a highly educated one. If you and your agent believe the appraiser got it wrong, you have the right to request a reconsideration of value. This is not a simple complaint. It's a formal evidence-based appeal. You can't just say, we think it's worth more. You have to prove it. Your agent will need to dissect the appraisal report page by page. Did the appraiser use the correct square footage? Did they list the right number of bedrooms and bathrooms? Sometimes, simple data entry errors can drastically change the value. More importantly, you need to look at the comparable sales, or comps. These are the recent sales of similar nearby homes that the appraiser used to determine the value of your potential house. Maybe they missed a crucial comp. A house down the street that was almost identical to yours but sold for $25,000 more just last month. Maybe they used a comp that was clearly inferior. It didn't have a finished basement, or it backed up to a noisy highway. You can gather this evidence, new comps, a list of factual errors, a list of upgrades the appraiser might have overlooked, and submit it to the lender for the appraiser to review. Will it work? It's a long shot. Appraisers don't like to admit they were wrong. But it's not impossible. If you can present a compelling fact-based case, they might adjust the value. Even an adjustment of $5,000 or $10,000 can be enough to bridge the gap and save the deal. It's a legal maneuver that costs you nothing but time and effort, and it's always worth exploring before you give up or write a huge check. So that dreaded phone call about the low appraisal isn't the end of the world. It's the start of a critical new phase. It's a test of your nerve, your finances, and your agent's skill. By understanding your legal rights under the appraisal contingency and your strategic options, negotiating, paying, walking, or challenging, you transform from a victim of the process into an active, empowered participant. Let's say you navigate this minefield. The seller agrees to lower the price and the deal is back on. You've cleared the financing hurdle, you've cleared the inspection hurdle, and now you've cleared the appraisal hurdle. The path is clear. The finish line is in sight. You're just weeks, maybe even days away from getting the keys. This is the point where most buyers finally relax. And that is a huge mistake. Because the final 2 weeks of a real estate transaction are a frantic sprint through a blizzard of legalese, a mountain of paperwork known as closing. This is where hidden fees can suddenly appear, where critical deadlines are absolute, and where a single overlooked signature can unravel everything. You're about to be handed a document called the closing disclosure, the final legally binding breakdown of every single penny in the transaction. And understanding it is the last line of defense for your wallet. This isn't just a piece of paper. It's a 5-page legal confession from your lender, laying bare every single dollar and cent that will change hands. By federal law, you must receive this document at least 3 business days before you are scheduled to close. This is not a suggestion. It is a non-negotiable right. It's called the TILARESPA Integrated Disclosure Rule, or TRID, but you can just call it your 3-day cooling-off period. This rule was born from the ashes of the 2008 financial crisis, a direct response to the predatory practice of lenders sliding a completely different set of numbers in front of buyers at the closing table when it was too late to back out. They'd bank on your excitement and emotional fatigue to get you to sign anything. The 3-day rule is your government-mandated shield against that pressure. Forces a pause. It gives you time to breathe, to review, and most importantly, to question. So what are you looking for? The very first thing you need to do is pull out that loan estimate you received when you first applied for the mortgage. These two documents are designed to be compared side by side. The closing disclosure is the final exam. The loan estimate was the study guide. If the answers don't match, you have a problem. Let's break down the beast page by page. Page 1 is your mission briefing. It's the high-level summary. Right at the top, you'll see the loan term, the loan type like a 30-year fixed, and the purpose, which is likely purchase. Critically, you'll see your interest rate. Does it match what you were promised? Is it locked? Below that, you'll see your projected payments. This is a massive section. It breaks down your estimated total monthly payment into principal and interest, mortgage insurance, and estimated escrow. Does this number align with your budget? Does it match the loan estimate? A few $100s of difference here could be the difference between comfortably affording your home and being house poor for the next 30 years. Then you get to the bottom of page 1. Costs at closing. This gives you two big numbers, the closing costs and the cash to close. The closing cost is the total sum you're paying for the service of getting this loan and transferring the property. The cash to close is the actual amount of money you need to bring to the closing table. This is the big one. This is the number you'll be wiring or getting a cashier's check for. If this number is wildly different from your loan estimate, you need to sound the alarm immediately. Now flip to page 2. This is where the magic and the potential mischief happens. This is the detailed, itemized receipt for your closing costs. It's broken into sections. Section A, origination charges, are the fees your lender is charging you directly. This includes things like application fees and underwriting fees. These are considered zero-tolerance fees. That means they legally cannot increase from what was on your loan estimate. Not by $1. If they have, you found a direct violation and they must fix it. Section B is for services you couldn't shop for. Think appraisal fees, credit report fees. The lender chooses these providers. These fees are allowed to increase, but only by a combined total of 10% from your loan estimate. This is the 10% tolerance category. It gives a little wiggle room for legitimate cost changes, but prevents the lender from lowballing you at the start and then jacking up the prices with third-party vendors. Section C is for services you could shop for. This is where your title insurance, pest inspection, and survey fees live. If you used a provider recommended by your lender, these also fall under the 10% tolerance rule. If you chose your own provider, the lender isn't responsible for what they charge. This is a key reason why it pays to be an active participant in your own transaction. As you go down the page, you'll see other costs: taxes, government recording fees, and prepaids. Prepaids are things you pay for in advance at closing, like your first year of homeowner's insurance or property taxes that need to go into your escrow account. Scrutinize every line item. Do you see a fee you don't recognize? A processing fee or funding fee that wasn't there before? Question it. Lenders are businesses, but mistakes and sometimes junk fees can and do happen. It's your money. You have the right to know where every single penny is going. Page 3 is the grand finale of the numbers. It's called the Calculating Cash to Close table. This page is the ultimate reconciliation. It takes all the numbers from the previous pages and puts them together to show you exactly how they arrived at that final cash to close figure. It starts with the sales price of the home, adds in your closing costs, and then subtracts things like your earnest money deposit, any credits the seller agreed to give you, and the loan amount itself. The final number at the bottom of this table should match the number on page 1. If it doesn't, there's a math error somewhere in the document, and it needs to be corrected. This page is your proof. It's the mathematical story of your purchase. Pages 4 and 5 are the fine print, but they are legally binding fine print. Page 4 will detail your escrow account. It will show how much the lender will collect from you each month for taxes and insurance, and when they plan to pay them on your behalf. Make sure this looks right. Page 5 contains other critical disclosures. It confirms the loan assumption policy, whether someone can take over your loan if you sell the house. It details late payment fees, and it contains a contact information section. Verify that everyone, the real estate agents, the lender, the title company, is listed correctly. This page also has the place for your signature, but you're not signing yet. Not at home. You are just reviewing. Your signature on this document at this stage only confirms that you've received it. It does not mean you agree with it. So what happens if you find an error? A fee that's too high, a misspelled name, a wrong loan amount? You don't panic. You pick up the phone. You call your loan officer immediately. You email them, pointing out the specific line item and the discrepancy compared to your loan estimate. You loop in your real estate agent. This is precisely why the 3-day rule exists. It's a mandatory window for corrections. In most cases, it's a simple clerical error that can be fixed. The lender will issue a revised closing disclosure. Now be aware. If certain things change, like the interest rate or loan product, or if a prepayment penalty is added, the 3-day clock resets. The law ensures you get a full 3 business days to review any major changes. While you're dissecting the paperwork, there's one final physical task you must complete: the final walkthrough. This usually happens 24 to 48 hours before closing. This is not another home inspection. You're not looking for new problems. You are there for 2 reasons only. First, to verify that the property is in the same condition it was in when you signed the purchase agreement. No new holes in the walls, no missing appliances, no flooded basements. Second, you are there to confirm that any repairs the seller agreed to make in writing have actually been completed. If you negotiated for them to fix a leaky faucet or patch a hole in the drywall, you need to see it with your own eyes. Bring your contract with you. If there's a problem, if the seller has moved out and taken the refrigerator they were supposed to leave, or if the agreed-upon roof repair was never done, you immediately tell your agent. This is your last point of leverage before the money changes hands. Resolving it might mean a credit from the seller at closing or a delay, but it's far better to deal with it now than after you own a problem. With a corrected and confirmed closing disclosure in your possession, and a successful final walkthrough under your belt, the fog of the transaction begins to clear. You've navigated the inspections, the appraisal, the underwriting, and the final critical numbers. You are now prepared. You are walking into that final room, the closing office, where stacks of paper and a set of keys are waiting. But what actually happens at that table? Who else is in the room? And what are the dozen or so documents you're about to sign that will legally bind you to this property for decades to come? The closing table isn't a finish line. It's a carefully choreographed legal ceremony, and understanding your role in it is the final piece of the puzzle. Let's demystify that ceremony. You walk into a conference room. The air is still. There's a lawyer or a title agent, known as the closing agent, sitting at the head of a large, polished table. And in front of your chair is a stack of paper so thick it looks like the manuscript for a novel. This isn't just paper. This is a collection of the most powerful legal instruments you will likely ever sign. Your heart might be pounding, a mix of excitement and pure, uncut anxiety. This is it, the moment of truth. Before you even think about picking up a pen, there's one document that acts as your final shield, your last line of defense against financial surprise. It's called the closing disclosure, or the CD. By law, you must receive this document at least 3 business days before you sit down at this table. This isn't a suggestion. It's a federal mandate under the TILA-RESPA Integrated Disclosure Rule, or TRID. Think of it as a mandatory cooling-off period. The law recognizes the immense pressure of this moment and forces a pause, giving you 72 hours to review every single number, every fee, every credit, without someone staring at you, waiting for a signature. The closing disclosure is the final, itemized bill for your home purchase. It details your loan amount, your interest rate, your monthly payment, and a dizzying list of closing costs. This is where you compare the final numbers to the loan estimate you received at the beginning of the process. Do they match? Is that document prep fee what you were quoted? Did the seller's credit for the roof repair actually appear? That 3-day window is your time to be a detective. If you find a significant discrepancy, you have the right to question it, to demand answers, and potentially, to delay the closing until it's corrected. Ignoring the closing disclosure is like skipping the final chapter of a mystery novel and just hoping it all worked out. It's a legal protection you cannot afford to waive. Once you're satisfied with the CD and you're at the table, the signing begins. The closing agent will guide you, but 2 documents in that giant stack carry more weight than all the others combined. They are the heart of the entire financial and legal transaction. They are the promissory note and the mortgage, or in some states, the deed of trust. First, the promissory note. This is the simplest and yet most terrifying document you will sign. Stripped of all the legalese, it's an IOE. It is your personal, unconditional promise to repay the loan. It states the total amount you borrowed, the interest rate, the dates payments are due, and where to send them. But here's the critical part people miss. This document binds you personally. It's not just a loan against the house. It's a debt attached to your name. If you were to default on the loan and the bank foreclosed and sold the house for less than you owed, the promissory note, in many states, gives the lender the right to come after your other assets, your savings, your investments, your future wages, to cover the difference. This is called a deficiency judgment. When you sign that note, you are making a legally enforceable promise that transcends the property itself. It is the engine of the loan. But a promise isn't enough for a lender who just handed over hundreds of thousands of dollars. They need security. They need collateral. That's where the second heavyweight document comes in, the mortgage or the deed of trust. They function similarly, so for simplicity, we'll call it the security instrument. If the promissory note is the engine, the security instrument is the key that gives the lender control. This document is what legally ties your loan to your new house. It gives the lender a security interest in your property. It's the document that contains the clause you've heard of, the right to foreclose. By signing the mortgage or deed of trust, you are giving the lender permission to seize and sell your property if you fail to uphold the promises you made in the promissory note. Namely, paying back the loan on time, paying your property taxes, and keeping the home insured. This document gets recorded in the county land records, creating a public notice called a lien. This lien announces to the entire world that while you hold the title, someone else has a financial claim against your property. That claim remains until the very last penny of the loan is repaid. The promissory note is your promise. The mortgage is the consequence if you break it. They are a one-two punch of legal obligation. After you've signed your personal freedom and your property away, just kidding, sort of, you get to the prize. The document that makes it all worthwhile, the deed. This is the legal instrument that actually transfers ownership of the property from the seller to you. It's the property's equivalent of a car title. The closing agent will have it prepared, signed by the seller, and ready for you. You'll want to see the words General Warranty Deed at the top. This is the best type of deed for a buyer. It's the seller's greatest promise to you. A general warranty deed means the seller is guaranteeing they own the property free and clear of any hidden claims, not just during their ownership, but throughout the entire history of the property. They are legally promising you a clean, undisputed title. If some long-lost heir of a previous owner shows up 10 years from now claiming they have a right to the property, the warranties in that deed legally obligate the seller you bought it from to defend your title and cover your losses. This document is your proof of ownership. It will be recorded in the same public records as the mortgage, officially and forever engraving your name into the chain of title for that piece of land. Of course, it doesn't stop there. You'll sign a mountain of other papers. An affidavit confirming your name and identity. A form for the IRS detailing the sales price. Disclosures about lead paint or flood zones. Each one is a small, legally binding statement. Feels endless. Your signature will become an illegible scrawl. Your hand will cramp. But with each signature, you are weaving yourself deeper into the legal fabric of this property. Finally, after the last page is signed and notarized, the magic happens. It's called funding. The closing agent, who has been holding your down payment and closing costs in a special trust account called an escrow account, gets the green light from your lender. The lender wires the massive loan amount into the escrow account. In an instant, the agent disburses all the funds, paying off the seller's old mortgage, paying the real estate agents, paying the title insurance company, paying themselves, and finally, paying the seller the net proceeds. When the money has moved and the agent confirms the new deed has been sent to the county for recording, that's the moment. That's when someone slides a small set of metal keys across the table. They feel impossibly light for what they represent. They represent the culmination of months of stress, saving, and legal navigation. You are a homeowner. The deal is closed. You walk out of that office, keys in hand, and drive to your new address. You put the key in the lock, turn the tumbler, and push the door open. The feeling is indescribable. It's yours. Every floorboard, every window, every blade of grass. You've done it. But as you step across that threshold, a new legal reality settles in. The transaction is over, but your legal journey has just begun. The rights you've gained and the responsibilities you've just inherited extend far beyond simply making a mortgage payment. What can you legally do on your property? What are your obligations to your neighbors, to your city, to the public? You hold the keys to the castle, but now you have to understand the laws of the kingdom. And those laws of the kingdom are often invisible, yet they shape everything around you. They dictate whether the lot next to your quiet home can become a roaring factory, or must remain another quiet home. They determine who can walk or drive across a corner of your land and why. These are the day-to-day rules of property ownership, the ones that govern not the purchase but the living. Let's start with the biggest one, zoning. Imagine you finally bought your dream home. It's a beautiful house on a quiet tree-lined street. The kids can play in the front yard. It's perfect. Then one morning you wake up to the sound of bulldozers. The empty lot next door has been sold, and a developer is putting up a 24/7 gas station and truck stop. Your property value plummets. The peace and quiet you paid for is shattered. This is the exact nightmare that zoning laws are designed to prevent. Zoning is essentially the city's way of creating a master plan. It's a rulebook that divides the entire community into different districts, or zones. You'll have residential zones, commercial zones, industrial zones, agricultural zones. Within the residential category, you might have R1 for single-family homes, R2 for duplexes, and R3 for larger apartment buildings. The goal is to keep incompatible uses separate. It ensures that a slaughterhouse can't open up next to an elementary school. It keeps the residential areas peaceful, and the commercial areas bustling and efficient. It's the invisible hand that preserves the character of a neighborhood and, by extension, your investment. When you buy a property, you're not just buying the land and the building, you are buying into its zoning designation. So before you ever buy, look up the local zoning map. Understand what's permitted around you, because that will define your experience of living there for years to come. Now let's zoom in from the neighborhood level to the property line itself. Have you ever heard of an easement? Sounds technical, but the concept is simple. An easement is the legal right for someone else to use a portion of your property for a specific purpose, even though you own it. The most common example is a utility easement. That 10-foot strip at the back of your yard? The power company might have an easement to run power lines there. The city might have an easement for a sewer main. You still own that land, you can mow it, you can plant a garden on it, but you can't build a permanent structure there because the utility company needs to be able to access their equipment. But there are other kinds too. An easement by necessity can happen if your neighbor's property is landlocked, meaning they have no other way to get to a public road except by crossing a piece of your land. In that case, the law can grant them an easement to build a driveway. The crucial thing to understand about easements is that they run with the land. This means the easement is attached to the property's deed, not to the owner. When you sell the house, the easement doesn't disappear. The next owner is bound by it just as you were. It's a permanent feature of the property's legal DNA, and it's something your title search should uncover before you close. It's a perfect example of how your property rights can be shared. A reminder that no piece of land is truly an island. Beyond the city's laws and legally mandated easements, there's another layer of rules you might encounter, especially in newer subdivisions or planned communities. Covenants, conditions, and restrictions. You probably know them by another name, the HOA or Homeowners Association. If zoning is the public law of the land, CC and RS are the private law of the neighborhood. These are rules created by the developer and enforced by the HOA to maintain a certain standard and aesthetic, with the stated goal of protecting everyone's property values. These are the rules that might dictate the exact shade of beige you're allowed to paint your front door. They can regulate the height of your fence, the type of mailbox you can install, whether you can park a boat in your driveway, or even how often you need to mow your lawn. To some, this is a fantastic system. It prevents your neighbor from painting their house neon pink with purple polka dots, or letting their yard turn into a jungle, which in turn keeps the whole neighborhood looking pristine and desirable. To others, it can feel like an infuriating loss of personal freedom on the very property they own. When you buy a home in an HOA community, you are legally agreeing to abide by these rules and pay the associated fees. Ignoring them can lead to fines and, in extreme cases, the HOA can even place a lien on your property. So before you fall in love with a house, get a copy of the HOACC and RS and read every single word. Decide if you can live by their rules, because once you buy, you're in the club whether you like it or not. Finally, we arrive at the most personal and serious aspect of property ownership: your liability. Holding the deed to a property doesn't just grant you rights, it burdens you with responsibilities. Chief among them is the duty of care. You have a legal obligation to maintain your property in a reasonably safe condition for others. This is where the classic slip and fall lawsuit comes from. If the mail carrier slips on your icy, unsalted walkway and breaks their leg, you could be held liable for their medical bills and more. If a guest trips on a broken step you knew about but didn't fix, you could be on the hook. The law even extends this duty in a limited way to trespassers. While you don't have to make your property perfectly safe for someone who isn't supposed to be there, you can't intentionally create a hazard. And this duty is much, much higher when it comes to children. This is a legal concept called the attractive nuisance doctrine. If you have something on your property that is both potentially dangerous and likely to attract children, like a swimming pool, a trampoline, or an old abandoned refrigerator, you have a heightened responsibility to secure it. If a neighborhood child wanders into your unfenced yard, falls into your pool, and drowns, you could face devastating legal and financial consequences. This is precisely why homeowners insurance isn't just a suggestion from your mortgage lender. It's an absolute necessity. It is your financial shield against the immense liability that comes with owning a piece of the world. And so we've come to the end of our 10-part journey. We started with the simple, powerful idea of a key unlocking a door. We navigated the labyrinth of contracts, the mountains of financing, the murky waters of title searches and closing costs. We've seen how owning property is far more than a transaction. It's an intricate dance with the law at every step. From the moment you dream of buying, to the day you finally live on your land, the law is your silent partner. It's the framework that gives your deed its power. It's the set of rules that protects your investment from a factory next door, and the system that holds you accountable for a broken step. Real estate law isn't designed to be a barrier. It is the invisible architecture of our society. It's the complex code that allows millions of us to live side by side, to build communities, and to pursue that fundamental piece of the American dream. Understanding these principles doesn't just make you a smarter buyer or a more responsible owner. It makes you a more informed citizen. The deed gives you title to the land, but knowledge of the law gives you true mastery over your domain. It transforms you from a mere resident into a guardian of your investment, a cornerstone of your community, and an active, empowered participant in the great, ongoing story of American property. Own your property, but more importantly, own the knowledge that governs it.